Good afternoon, everyone, and welcome to today's training, Intellectual Property Fundamentals. I'm Rebecca Chauncey, a business advisor here at the Illinois Small Business Development Center, or SBDC, at Build Bronzeville. Pleased to have you join us today. This training is brought to you at no cost because it's funded in part through a cooperative agreement through the United States Small Business Administration, or the USSBA, the Illinois Department of Commerce and Economic Opportunity, and locally by Urban Juncture Foundation. Just a couple of housekeeping notes. Today, if you have questions throughout the training, you should type them in the Q&A section, which you'll see if you hover over the bottom of your screen. You'll see the Q&A, and again, type any questions you have there. If relevant in the moment, I will share them with our presenters. And there will also be time at the end of the training for Q&A. Additionally, just so you know, you will receive a recording of this, and I'll tell you a little bit more about what else will come in that follow-up email that I'll send. So I'm so pleased to introduce you to today's presenters. Renato Smith, Born Freedom, is a partner at Barclay Damon, LLP, a general practice law firm with about 300 attorneys operating from a strategic multi-office platform. With a focus on pragmatic solutions for clients, Renato practices in the areas of intellectual property, licensing, commercial transactions, data privacy, and dispute resolution. Renato is co-chair of Barclay Damon's Data Security and Technology Practice Area, serves as DEI advisor to the firm's Summer Associate Program, and is former co-chair of the firm's Trademarks, Copyrights, and Licensing Practice Area. Renato is licensed, to practice law in Illinois and New York. Celine Dorseyville is also with us. Celine is an associate at Barclay Damon, LLP, in the Data Security and Technology and the Trademarks, Copyrights, and Licensing Practice areas. Her practice focuses on providing legal counsel to clients in the areas of data privacy, cybersecurity, intellectual property, licensing, and commercial transactions. She is licensed to practice law in New York. I am so pleased to pass the mics over, if you will, to Renato and Celine.
Thank you, Rebecca. We appreciate the opportunity and are honored to support the SBDC's efforts for Illinois, Build Brownsville, to help small businesses advance and progress and generate jobs. So with that, what I'm going to do is turn to the first slide. Today, we're going to talk about a number of topics. I'll speak on a few slides. Celine will speak on a few slides, but please feel free to interject during the slides presentation with questions, comments, so it's more of an interactive presentation. But there will be time at the end for Q&A as well. So having said that, let's begin by talking about what we want to cover today. For intellectual property, we will discuss the 4 basic buckets of intellectual property: patents, trademarks, copyrights, and trade secrets. And then finally, we'll go on to 10 practical tips for small businesses, and we'll have Q&A at the end. The United States Constitution provides the basis for patent and copyright laws. There's a clause which says in Article 1, Section 8, Clause 8, that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And what's notable is limited times. So when it comes to copyrights and patents, there is a limitation on how long you have this government-granted monopoly, and we'll get to that in a bit. Looking a little bit deeper, let's discuss patent rights. For patent rights, you will think of things such as a process, a machine, a manufacturing method, a composition of matter, or an improvement. There are design patent rights, there are utility patent rights. We'll talk about that in greater detail. But these rights are granted under the United States Patent Act, USC Title 35, and the rules are in CFR Title 37. Are they registrable? They are, again, as utility patents or design patents in the United States. For trademark rights, you'll think about things like the name of a business, a brand, a product, or a service, a logo, a slogan, or another identifier of source of a good or service. There's a lot of confusion sometimes between trademarking something, patenting something, copyrighting something, but hopefully this chart helps you keep the distinctions clear. When you think about trademarks, think about names primarily and brands. These rights are granted under what's called the Lanham Act in Section 15 USC Section 1015. And they are registrable at the federal level, and they also are registrable at the state level. For copyrights, you will think about things like works of authorship, such as a book, a musical work, a photograph, a video, software. Copyrights are registrable, and there's a process for doing that, which we'll describe later. And this is also set forth in a USC in Title 17. For the copyright side, or for the trade secret side, it's a little different. They're not registrable. For trade secrets, you will think of things like a formula, a recipe, a customer list, an operating or manufacturing procedure, a secret sauce of a food ingredient, or a software source code. Again, you don't register these. They're not registrable under the law. However, there are various acts that allow one to protect and defend one's trade secret rights if you observe certain criteria. Let's take a look at patents in a little greater detail. Generally speaking, patents provide the patent owner with the right to exclude others from making, using, or selling or importing a device or an embodiment of an invention. The term is granted for 20 years from the filing date for utility patents. For design patents, it's 15 years from the issuance of the patent. Patent rights initially vest in the inventors. So in this case, what I have shown here on the top right is an example of a utility patent for a vertical takeoff and landing aircraft. You may have heard about these vertical takeoff taxis that a lot of startup companies and some larger companies, including Toyota, are working on, with the goal of eventually allowing people to have a taxi that is airborne in cities so you don't have to deal with road congestion. And this is an example of an inventor who has come up with an invention or conceived of an invention in this area. It shows the name of the company, the S&E, which is the owner of the patent issued on February 27, 2024. And then on the lower side, we have an example of a design patent. So this is design patents protect not functionality, not utility, but they protect the look of an object, the ornamental look of an item. So in this case, someone, an inventor, conceived of a particular look for a handbag. And as you can see, the handbag is drawn here. And unlike utility patents, for design patents, 90% of everything in a design patent are the drawings, because it's all about the look. So you'll see many different angles and different types of shading and uses of dotted lines and solid lines to try to claim things in different ways, but it's all focused on the look and feel, so to speak, of the item. And generally, design patents are easier to obtain, but provide not as robust of protection as a utility patent. And Celine, you're up for the trademark registration.
Thanks, Renato. So as Renato mentioned, you can get a trademark registration typically for the name of your business or a logo or a slogan. So for example, we have Google here. Google applied for their trademark in 1998, and they received that registration in 2004. And so what this trademark registration does for Google is it allows them to have enforcement rights against any other businesses or persons who want to create, for example, a word search engine that indexes information that they would like to title themselves also as Google. Google has the protections against another business from being able to do that, because it would create a likelihood of confusion of to us as consumers of what is the real Google. So Google has that protection. And the term for such protection is perpetual. So Google was granted this registration in 2004, and Google will be able to maintain and keep said protections and registration forever, as long as they properly renew with the United States Patent and Trademark Office every 10 years. And as Renato mentioned, you can get you can get trademark registrations at the state level, but that would only protect you within that state. So for example, if Google only had a trademark registration in California, they could only protect against other businesses wanting to have a word search engine titling themselves also as Google. They can only protect against that in California. So the benefit of a federal registration, trademark registration, is that you will be able to have the protection across the United States. So that provides national rights, and it also grants enhanced remedies. So you will have access to enforce these rights against other individuals in the federal courts, as well as maintaining a presumption of validity, constructive notice, and other rights. Next slide, please.
And I'm just going to mention one thing about phonetic confusion, Celine.
Mhm.
What we see a lot of times is companies, small businesses, startups are interested in using a particular brand. They may do their own search or have a law firm do the search and find out someone, has a mark that is dead on, a registration for a mark. And the question is, we get a lot of times is, well, can we just change some letters? So for example, with Google, the question might be, could we use something, let's spell G-U-U-G-L-E or G-O-O-G-O-L, where it sounds like Google, but it's spelled differently? The answer is typically no, because the likelihood of confusion analysis is not just about the written words, it's about the sounds. So if someone would be confused if they heard that on a radio or a television broadcast, and they would because it would sound the same as Google, you have a problem. So that's not typically not a quick fix. Just wanted to mention that, Celine.
Copyright registrations. So similarly to the trademarks, you can file with the United States Copyright Office to protect your copyrights. And what benefit does that give to you? Well, you will have the exclusive right to reproduce said copyright. So if, for example, we have Michelle Obama here with Becoming, she has the exclusive right to reproduce this text in any variation. So translations, if they want to do, I think this came out in 2018. So if in 2028 she wants to do a 10-year republishing, she can do that because she owns the copyright. So she has the right to reproduce, distribute copies, and control how it's displayed. And the term for the copyright registration is the life of the author plus 70 years. So Michelle Obama will have the copyright registration to her book Becoming for the entirety of her life plus 70 years thereafter. And so the copyrights initially belong to the author. So for example, here, Michelle Obama she's the author of this book, and she owns the copyrights. And you can see that she has that registration to herself as well. And then she can go and license the copyright to, her publisher so that they can produce the books for her and distribute them for her. But she controls the rights to do so. Similarly with businesses, the employer is considered the author of a copyright. If you have an employee who is creating a very valuable employee manual for the runnings of your business, the employee, even though they created and physically prepared the manual, because it's in the scope of their employment. However, you as the employer will be considered the owner and the author of the copyright. Next slide, please. Trade secrets. Now, unlike copyrights and trademarks, there is no official filing that you can do to register a trade secret. And a trade secret, we have our examples on the slide here, are the Coca-Cola formula. We don't know what goes into Coca-Cola. Pepsi tried to recreate it, but it's not exactly what goes into the Coca-Cola formula. Same thing with Google. We don't know what the internal search algorithms are for Google's algorithm that produces and populates results for us. And lastly, Kentucky Fried Chicken, we don't know what the exact seasonings are or what the exact measurements are that go into preparing chicken at KFC. And so these are all considered trade secrets. Now, again, you can't register for protection, but you do have some federal protections, statutory protections, and enforcement rights against those who might want to misappropriate said trade secrets. So if, for example, KFC has an employee and they take the recipe home with them and they decide to start a business called Tennessee Fried Chicken, and they're using that recipe that they took from Kentucky Fried Chicken, KFC has the enforcement rights to put a stop to that. And the term for trade secret protections are perpetual as long as KFC uses reasonable efforts to maintain the secrecy of their recipe. So just giving it to employees so that they can replicate it in their scope of work does not mean that they're not maintaining the secrecy of the information. Maintaining secrecy means that it's not publicly available. KFC doesn't post their recipe on a public blog site. They're not openly sharing what goes into creating their chicken. And then additionally, the information, as long as if the information being kept a secret creates the economic value, and it can't be readily ascertained, so not publicly available, then that is what protects your trade secret. So KFC, as long as they're not publicly posting their recipes and them keeping a secret, creates an economic value for them. I mean, we have so many KFCs across the country and the world. There is an economic value in keeping that chicken recipe a secret. And so for the small businesses, if you do have a cake recipe or something of that nature, and the cakes are why you're selling out your business every week, that creates an economic value. And if you're not posting your cake recipe on Facebook and on Pinterest, then you would have trade secret protections over that cake recipe.
And I would just add to that, we a lot of times we'll call it lock and key procedures or lock and key measures. If your business has something that's particularly valuable that you want to maintain secret, it should go without saying that you want to have a non-disclosure agreement in place with everyone who accesses that information. But above and beyond that, you should be thinking about technical measures. So for instance, if there's 10 steps to the recipe, you don't put all 10 steps on one document or one file or in one server. You separate them. You come up with creative ways so that if someone perhaps if there's a breach, they don't get the full recipe or the full formula or your full methodology. You may designate certain people who have access to different parts of the trade secret. But anyway, I just wanted to mention these lock and key procedures are important above and beyond just an NDA.
Next slide, please. Perfect. Okay, so starting with our small business tips. So as we discussed prior, trademark registrations are very important to businesses. And so a step before going out and filing for a trademark application, businesses that decide to use a new name for a business product service should follow these steps before marketing and advertising said business product or service. First, we recommend performing a trademark search on the United States Patent and Trademark Office website. It's a public domain. You can go in and you can go in, or you can have a lawyer go in and just perform a preliminary search to see if anybody's using this new name or logo or slogan in the same goods or service that you are planning on doing with your business. So, for example, you're a sneaker business and you want to produce a new sneaker and you want to name it the Jordan 32s. And then you go in to the trademark office and you see that Nike actually has a trademark over Air Jordan or Jordan 4s, might be a sign that you want to possibly rename your sneaker or shoe, because that name is already in use and very specifically in the same good or service that you were planning on using it for. Secondarily, perform a very simple online search to see how, if and how competitors are using similar names. We want to make sure that you can maintain the most robust IP protections, and an easy way to start to ensure that is to use a name that nobody else is using, so then there isn't any contention or difficulties in you protecting yourself. And lastly, check the availability of a domain name or social media account. Doing a simple website search would be very helpful. You wouldn't want to create branding and logos and start naming your business and then find out that you can't get the website domain, or because it's already in use, or someone already owns it and it's just not cost effective to try to buy it from them. And then similarly with social media accounts, it's very important for businesses to maintain consistent branding across Facebook, Instagram, Twitter, what have you. So making sure that you're able to have consistency for your brand across all of these platforms will be very beneficial.
I just want to mention, Celine, we know that the USPTO's search interface was updated recently.
Yes.
So I just wanted to mention that it's somewhat tricky because it is an easier, more intuitive interface to conduct your own search at the USPTO's website for a trademark. However, the results don't give you necessarily the full picture if you don't really know how to run those searches. So if you treat it just as like a Google search engine and you put in Acme code and you're going to get a result, you don't want to just stop there and think, oh, I don't, it looks like there's no hits, I'm good, because the way that system is designed, it doesn't give you necessarily all the phonetic equivalents, the expanders, the variations that you should be considering for a trademark search. So I would just say, if you're going to do that search on your own, make sure you spend the time to understand not only the basic search, but how to conduct an advanced search, and there are tools and tips on how to do that.
Pardon me, I just wanted to add one more thing before you speak again, Celine. Sure. Everyone, there are some people I think that joined after my initial announcement. Please add any questions you have in the Q&A section. If you look at the bottom of your screen, you'll see that. And again, if it's relevant in the moment, I will share it with our presenters, but there will also be time toward the end of the training for Q&A. Thank you.
Thank you. Moving on, Celine.
Small business tip number 2. Okay, so you performed all the preliminary searches and you're ready to get the proper registrations. So before a business launches into marketing or advertising of this business name or logo or product, we recommend filing an intent to use trademark application for such marks and logos. And so that is just telling the USPTO, hi, I have this product, business, or service that I would like to use this name or logo for, and I am planning on utilizing such marks in commerce in the future. But for those who say, well, I've been in business for 10 years and I've been using this mark and logo, am I not able to file a trademark? No, that's not necessarily the case. We perform all the preliminary searches and you're good to go to file your application. You would be filing a in-use trademark, which is letting the USPTO know, hi, I've been using this trademark, I would like to register it. And then you would provide them with evidence of the first time you used it. So maybe the first time the first day of your website, the first day you created your Instagram, just something to let the USPTO office know that you've been using this mark and you would like to seek protections for it. Then similarly with the copyright applications, before publishing any original work of authorship that is important or valuable to the business should file a copyright application for the work with the US Copyright Office. And these filing fees do have a range, but for trademarks, they start at $250 per application, depending on the type of application that you're filing for. But it's typically $250 for a single class of goods or service. So with the Nike example, for athletic apparel, that is a singular class of goods or service. Now, if you wanted to do athletic apparel, and also Nike has an application, so let's say a mobile phone application, those would be two separate classes, goods or services. So keep that in mind. And if you want to add that additional class, it would be that additional application fee on top of that. And then again, copyrights start at $45 per application.
And I'll just mention the ownership because we get this question a lot about who owns the trademark. Is it the individual? Is it the founder? Is it the LLC, the corporation? It's whatever entity used the mark in commerce to identify a source or good. So if if a person does not have an LLC or corporation form, but is still running a business and is using that trademark in connection with the business, the person, that individual is the owner, and so would be listed as the owner of the trademark application upon filing. However, if the person was like a manager or a CEO of a corporation, then the corporation, if it was using that mark, you go to the website, you see the corporation's name, and the product name or the product mark or the trademark there is branded. That's the company. So the company would be the owner of the trademark application in that case.
Perfect. Okay, so tip 3. Like we mentioned before, I think Renato mentioned wanting to make sure that you have proper agreements in place, not only with your employees. So in that trade secrets example, having an NDA or something to protect not individuals from being able to go and use the information that they gain from working, going out and sharing that information. Similarly, there should be proper contracts in place with collaborators and creators. And so what does that look like? Maybe there's an independent contractor situation where you have someone doing photographs for your business or doing the web design or logos. We want to make sure that before the business discloses any confidential information to any party or engages in an agreement to create something that the business will eventually be using, the business should require those parties to sign an agreement that not only has those confidentiality provisions that we discussed, but also directly states who will own the intellectual property after the agreement is over. So you would hate to be in a situation where you have a web designer design your website for you, and they own the domain and they acquired the domain name for you and they did all of the work for you, and then they later decide that they want to take control over that website or domain from you. You will be able to lean on that contract or agreement stating that actually, as a web designer, you agreed that after this agreement was over, I, as the business owner, will actually maintain the intellectual property ownership of the website, of the domain name, of the logo, of the photographs that are taken, etc.
Excuse me, Celine, we have a question.
Yes.
The person asks, when consulting, how do you protect yourself if you didn't have a contact, but provide support resources and documentation based on your expertise to a client? Also, the client has not paid your fee. So what's the best route of retaliation? Excuse me.
Renato, do you have?
Well, Yeah, no, I think it's a two-part question. On the first part, you don't have a contact, you perform something of value. A lot of times consultants will, in order to bring in business, showcase, here's my portfolio. Maybe I'll do part of a pitch or part of a media piece for you to kind of demonstrate what I can do before there's actual signing of a contract. And unfortunately, it's also very common for consultants to actually do the full engagement without a contract in place. They'll just send out an invoice, pay me, and there's no T's and C's that address confidentiality or intellectual property ownership. If that has already occurred, there are a couple things to think about, but I think the long and short of it is you want to be thinking about some type of negotiation with the client, and seeing what you can do and what leverage you may have from a business standpoint to try to get that client to sign an agreement after the fact. And the agreement can, if the parties had a kind of an understanding or meeting of the minds at the beginning, who would own what, you can reflect the effective date of that agreement to go back to that meeting of the mind state. So that can be one way to approach it. I think if you could repeat, Rebecca, the second part of the question.
Sure. The question is also the client has not paid your fee. So I guess it's the person is saying this client didn't pay a fee. So what's the best route of retaliation?
Mm. Well, so now we're talking about breach of contract. There was an agreement for party X, the consultant, to perform a service, and there was an agreement for the client to pay for that service, and the client didn't pay. Now, if that agreement is not memorialized in writing, it's what we will call an oral agreement. It's still an agreement. It's just difficult to enforce it because it's oral and there's less evidence. The long and short of it, again, is to go and you could, with an attorney, send out a demand letter for the fee, alleging breach of contract, any evidence that the consultant might have in terms of email trails or texts where the customer agreed to pay a certain amount can be used to kind of reconstruct the agreement and demonstrate the terms and conditions of the oral agreement. So there can be some legal action that could be used. That's kind of what's coming to mind at this point. All right, so Celine, are we ready to move on?
Yes. And I think we are passing to you, Renato.
Okay, and I'm just actually going to go back to this tip 3 because there was one other piece that I wanted to mention. On this tip, and I think the question from the audience member is a perfect example. You really have to slow down before you take on that engagement. I know, it's difficult to market, and you finally get a great opportunity, but I think small businesses should really be disciplined, and they should have a standard service agreement form, and should be using that continuously, systematically for every engagement. It should have the proper intellectual property and confidentiality provisions in it so you don't have those disputes after the fact. What I will say is 9 times out of 10, if you're a consultant, if you're hiring someone, if you're hiring someone to produce something for you, you want to have an agreement in place that says you own all the IP and all the deliverables. The one exception is typically in the music industry. So if you're dealing with musical recordings or other forms of music, there are reversionary rights that can be triggered by a transfer of intellectual property. And so you will typically see recording company agreements and label agreements where they want to see the creator as the employee rather than an independent contractor, because if they're an employee, like Celine was mentioning earlier, the employer or the record label is considered the author because the creation is by an employee and there is no transfer of the copyrights. They initially vest into the record label company, the producer, and you don't have these situations where 35 years later, the instrumentalist or the vocalist can come back and say, I want to pull back some of my copyrights. That's the one exception that we typically encounter. But generally, 9 times out of 10, if you're hiring someone, you should have something, a document in place that says, I own all the IP and all the deliverables, and you hereby transfer all right, title, and interest into that IP to me. All right, so I think then, I'm up on legal notices. We get this question quite a bit, whether or not you can use legal notices. And want to walk through this a little bit step by step. If you're sending a document that has what you would consider to be confidential information, maybe an internal procedure that you use to produce something, recipe, formula, and you're collaborating with someone, maybe someone's going to help improve your formula, your process, your ingredients. Make sure all those types of documents are labeled confidential information, bold, all caps, at the top, in the footer. It's difficult to go overboard, but you want it to be clear that you consider that to be confidential, you consider that to be your trade secrets. And that helps demonstrate that you've used reasonable efforts to maintain the secrecy of your trade secrets, which, as discussed earlier, helps position you to enforce those trade secret rights against misappropriators if and when a wrongdoing occurs. In terms of trademark notices, if you have a brand, a logo, a slogan, a business name that you consider to be your trademark and you're using it in that fashion, you don't have to get a registration in order to use the TM or the SM symbols. So as shown here, if you have product XYZ, XYX in this example, you can put the TM next to it, or service ABC, you can put the SM next to that. Once it's registered, and in this case, we're talking about a registration on the federal level with the United States Patent and Trademark Office. At that point, you can and typically should, in most cases, be putting the R in the circle symbol next to your product, next to your trademark usage, whether it's a trademark, whether it's a service or a product as shown here. Finally, let's shift over to the copyright notice. And this probably comes up more often than even the trademark questions. If you or someone within the company that you own creates a work of authorship, an original work of authorship, you can put your copyright notice in the footer at the beginning of the article, as we've shown here. Copyright 2024 Newco LLC, all rights reserved. You are not required to obtain a copyright registration in order to put that notice up. What you're doing is putting the public on notice of your common law copyrights. And we typically recommend doing that as well.
Quick question related to that, Renato. So with that copyright notice, would you, for example, let's say the work was originally created, let's say it's an article, right, that an employee, well, I won't say an employee, but the owner of this company wrote, and it was initially done in 2024, but they're going to share it in 2026. Do they need to change the date because to make it for 2026 if they don't change anything in the article?
Right. So yeah, that's a great question. You're not required to put, in your case, 2024-2026. You're not required to do that. You can do that. And it really depends on whether you do that, if you're going to be consistent. So if you're consistent across the board with putting the hyphen and the latter year, which represents when it was last updated, that's totally fine. However, if you think that you just don't have the consistency to kind of follow up with every single blog or article with that type of legwork, because it takes time and effort to manage that, unless it's automated, there's nothing wrong with keeping 2024 as the original date.
Thank you.
Sure. We're going to move on to fake reviews. So this is an interesting one. So earlier this year, the Federal Trade Commission issued an important rule that impacts a lot of folks in the social media space, in the marketing area. And the long and short of it is Don't get involved with fake reviews, fake testimonials, or fake influence. And we know that's been a common practice in the industry for years. Originally, the FTC issued guidelines to try to encourage people and help them understand what's appropriate and what's false or unfair and deceptive practices. And so hence you see in social medias the hashtag ad or hashtag paid advertisement. All that came about through the guidelines that the FTC issued years ago. The problem is people really didn't care. A lot of people just ignored those guidelines. And as the FTC went out to try to enforce them, was finding out it was difficult to do so with its traditional methods under litigation, and some cases came down, which made it challenging for the FTC. So in response, the FTC issued a rule on the use of consumer reviews and testimonials. This is binding. It's not a guidance. It is binding law. And it applies to influencers, endorsers, advertisers, marketing agencies, product manufacturers, and others. It lays out a number of prohibitions, and Celine and I put authored a article on this, which is on our website if you want to look at the full list. But generally, if you think about some of the more common bans that I think are notable, is there's a ban on reviews and testimonials that are by people who don't exist. And so, there's someone just making up that Jane Doe made this review, but Jane Doe doesn't even exist. Or it's a bot, it's an AI generated bot. Or reviews or testimonials that are not based on actual experience. So you have, all in the review space, people posting reviews about products that they say are great. I tried this, I had this result. It's not true. They never tried it at all, but they were paid to say that. There's a ban on that. And there's a ban on scripting, pre-scripts that are made by hiring parties. So if you're a marketing agency or you've got a new product that you want to launch and promote, and you found this influencer and he or she has this great following, you're not supposed to be under this rule writing out the script if that person is performing a testimonial on your product. That's supposed to come from the person's actual experience. There's also bans on buying and selling fake indicators of social media influence. So it's unlawful to purchase followers, and it's unlawful to purchase, for example, likes. The civil penalties are maxed out at $51,744 per violation. And so the question that is kind of floating around in the legal community and in the marketing community is, if a company has 1,000 fake reviews, is it 1,000 times 51,744? And I think that remains to be seen. What the FTC is saying is that's the maximum. There's going to be discretion, and it's not necessarily going to go to that level every time. But be cautious about this. This is something that is generating considerable waves in the marketing space right now. Returning to the topic of licenses to use works of others. So before a business right-clicks, downloads, or copies a work of another, the business should be doing a few things. One is reviewing the license terms. And if the license is too restrictive, buy a license for the intended use. What we find is a lot of times the license terms, the commercial license terms, are not that expensive and costly, even for small businesses. But small businesses are just not going through the work and the time to actually, once they find an image, make sure that it's at the appropriate website, read the terms, make the purchase, manage the terms, save them so you have them in the future. If you're called for an infringement, you can prove, no, we have a license, here's proof of the license. It takes administrative time and work to do all that, and a lot of people are busy on the fly putting together collages and websites and images for social media, and they don't really want to go through all that. But it is an important thing to do. We really recommend doing it, so you don't, you're not on the receiving end of a cease and desist letter or demand letter, which can trigger significant legal costs. This applies to online images, photos, videos, soundtracks, beats, all those types of works that companies can download. Free licenses are available. If you look, for example, at some of the platforms like Pixabay, Pixels, and Unsplash, they provide free licenses. There may be some limitations to the scope of use. In some cases, there are no limitations. You have to read the terms even for those images. And then finally, if you're looking just to kind of do your initial investigation and review on Google, Google does have use tools. You can filter the settings and look for things like Creative Commons and those types of platforms that provide works that are available under either free terms or relaxed terms. What are the statutory damages? Why does this all matter? At least from the copyright standpoint, if you're an infringer, you can be liable for anywhere from $750 to $30,000 per infringed work. And if the infringement is willful, which means that, for example, let's say you're a business and you're using an image on your website and someone says, hey, we just discovered that you're using this image. You don't have a license to do so. Stop using it and pay us $1,000 for your improper usage to this point. And you just ignore that. And 6 months go by, 12 months go by. You may get a demand letter from a law firm or a complaint where the plaintiff is alleging willful infringement, meaning you knew about the infringement because we told you about it. You continued to infringe regardless. Now we're looking at a $150,000 claim. Tip 7, music licenses for public playing or performance. If it may be necessary, if you run a store or operate a store, for example, where you have overhead music playing, to get a license from the following activities in the common areas of the store or the business facilities. This can come into play with respect to music via over-the-air, streaming, CD, karaoke machines, etc. Consider buying licenses from the streaming service. That's one of the go-to tips that we give to companies that are using music publicly in their spaces is to consider a streaming service, because that already includes and incorporates the underlying licenses that are needed from the owners of the copyrights and the works. Secondarily, there's a consideration for live performance of music. So if you have a bar or a restaurant and you bring in bands periodically to play music in a public space for the patrons, consider buying licenses from the performing rights organizations, such as BMI, ASCAP, CSAC, or GMR. We get a lot of these letters from these performing rights organizations that are levied against our clients who did not go through those steps, and their bands are playing music. And typically the performing rights organizations are pretty flexible. Typically if they find out you've been doing this for a while, but you're ready to go ahead and sign a license, they'll excuse the prior infringement if there were an infringement, as long as you sign on to their license and pay. The payment, it could be as little as $1,500 a year, or it could be slightly more depending upon how many facilities you have, how your workload, how frequently bands are playing, and some of those parameters. As discussed before, music is the same as other types of works. The statutory damage is $750 to $30,000 per infringed work. It can go up to $150,000 for willful infringement.
Excuse me, Renato, just wanted to inform you, we're at the 10-minute mark.
Thank you. I appreciate that, Rebecca. So we'll pick up the pace a little bit. Quality control obligations on the trademark licensees. If a business is allowing another party to use the business's trademarks or service marks, it is very important to include a quality control provision in a contract signed by the user of that trademark. If you don't do that, you can be in a position where you engage in what's called naked licensing, which means if you go to enforce your trademark rights against that party or someone else, the defense is this owner nakedly licensed his trademark rights to the public without quality control, and therefore those rights are not enforceable. And turning to you, Celine.
Yes. So if you see that someone has used your business's names, marks, materials on a social media platform that infringes on those trademark and copyrights, the business should report that infringement to the platform to request those accounts and posts to be taken down. But considering whether or not you should report such infringement, keep in mind that some platforms may require that there is some sort of proof of said trademark registration, copyright registration, or copyright ownership notice. So letting that someone know that you own the copyright and giving them time to take it down themselves. Next slide, please. And our last tip, seeing the uptick in the use of AI and creation of AI tools, we think it's important to review the terms of those AI tools and also note that when generating text, music, or artwork, they're utilizing an AI system. Currently, and Renato, correct me if I'm wrong, you cannot seek copyright protections of those AI generated works.
Yeah, and there's definitely some issues there. It depends upon kind of the amount within the total. But yeah, there are definitely challenges there.
And additionally, if you're using those AI tools that are making decisions about individuals, so maybe using AI tools to screen your employment apps, there is some legal risk there pertaining to potential AI bias and discrimination. And lastly, you should also read those terms to see if the AI tool providers are providing any protections of you. Say you create something using an AI generating tool and that infringes on somebody else's copyright. So you would want to see if that tool will protect you and indemnify you if that person wanted to enforce their intellectual property rights against you and your use of that tool. So we recommend just making sure that you really know what tools you're using and what the terms of those tools entail. And lastly, if there are any more questions, we'd be happy to answer.
If you have questions, type them in the Q&A section. Or if you're not able to type, please raise your hand and I will allow you to say your question aloud. But this is your opportunity to share any final questions before we wrap up. All right, we have a question. Let me allow you to talk, Perry. You can unmute yourself and ask your question, Perry.
Yeah, my question is, in terms of that, how long does it take to submit it? Well, I would say once submitted, how long does it take to get a return?
And are you referring to like a trademark application or one of the other?
Yeah. Yes.
Yeah, so for a trademark application, there's a process called prosecution. So you file day one. Typically, you will get an office action from the trademark office 6 to 12 months later. That's where the examiner picks up the case, analyzes it, sends back a response, says, "Oh, it looks good. I don't see any issues," or "There are some issues. We want you to change this or provide some arguments." So probably 6 to 12 months, we'll get an office action. And then if things go well, registration can be within maybe another 6 months after that point.
And there's no way to expedite it?
I'm not aware of a way to expedite it with the trademark. There are expedited procedures for patents, but we could get back to you on that. Celine, I don't know if you have any thoughts on expedited trademarks. I'm not aware of any.
No, there
Oh,
aren't
okay.
any way to expedite the application. But we recommend if you are thinking about pursuing a trademark registration, applying sooner rather than later because the trademark office is a bit backed up. Right now, I think they're reviewing trademarks that were submitted in May of this year. So if you want to get that ball rolling, just jumping on it sooner rather than later, because I know that they are a little bit backed up.
And also, I wouldn't be dissuaded by the fact that it takes a while to get a registration because with Amazon, last time we worked on an Instagram case, those platforms will take, if you've got an issue where someone's using your brand without authorization, they'll take even the evidence of a filed pending application. You don't necessarily have to have an actual registration. So you file day one, now you've got a serial number, an application number. You can submit that as evidence to the platform to say, I want you to take down this infringer's mark, and here's evidence of my pending application.
Okay, anyone else before, any final questions before we end? All right, it looks like that may be it. If you could advance to the next slide. All right, everyone. Thank you so much. Many, many thanks to Renato and Celine for sharing
Thank you.
their knowledge, their legal knowledge, and relatable examples of IP. I think that everyone here can say that they learned a lot, and I think that's partially why we don't have additional questions. You're still processing all of that insight. You will receive, just so everyone knows, you're going to receive a link to the recording of this so you can review it at your convenience. You'll also receive an email that requests your feedback on a survey about today's training. We love to provide training that is really relevant to business owners like you. And so please share your feedback. There's also room for you to suggest future training. So again, we want to make sure you get the best information so that you can do your best as a business owner. If you haven't already noted, you can reach out to Renato and Celine at their emails listed there in their firm, barclaydamon.com. If you're not already a client with us at the Illinois SBDC at Bill Bronzeville, you can email us or visit that link there at billbronzeville.com/SBDC to become a client. And technically, you registered for this training. So essentially, you could go in the same system that's eCenter and request to become a client. So you have options there. We thank you again for your time and attention. Here's to great success in your business and making sure you remain compliant in your business and stay out of courtrooms and lawsuits, right? And
Right.
here's to a wonderful holiday season and a very prosperous year ahead. I don't know if you have additional things you might want to share, Renato and Celine.
I think you put it well, Rebecca. Let's look forward to a wonderful year from a business standpoint and a personal standpoint.
Fantastic. Thanks, everyone, and have a wonderful rest of your day.